trade name of the company. K, to register company property in the name of the company, a fictitious trade name of the company, a trustee or nominee, so long as the company's ownership of such property can be clearly demonstrated. L, to make distributions in cash or in kind and to assign value to such property according to the trustee's best judgment. M, to accept additional to the trust estate by deed, will, assignment, exchange, gift, grants, insurance, proceeds, or any other methods deemed acceptable to the trustee. N, to elect and remunerate officers from the board or otherwise as deemed appropriate for the trust's best interests. O, to give proxies to deposit securities with and transfer title to committees representing security holders. P, to open margin accounts with security firms and commodity traders and to buy, write, or trade in options, commodities, and to make short sales. Q, to hold, manage, and operate any company, property, or business or enterprise. The profit and loss, if any, therefrom, shall be chargeable respectively to the trust estate. R, to pay all taxes out of the trust estate where taxes are required by law and to have complete discretion, power, and authority to make any decisions and elections. S, the trustee may expressly delegate one or more of their powers to any other person or persons that may be deemed appropriate for that role. T, the trustee by a majority vote may change the domicile of the company with or without cause if they deem such change will protect or benefit the trust estate. U, the trustee by unanimous vote may make amendments to the contract or declaration or any type of constitutions of incorporation and to such other consequential actions as they deem necessary. V, the trustee by majority vote may at any time and at their sole discretion wind up company affairs, terminate this trust, and make distribution of the trust estate to certificate holders as provided herein. Article 6, Acceptance by Trustees. Section 1. The first trustee for himself or herself and all subsequent trustees and successor trustees by accepting the appointment of the trustee of the trust calls all present and future trustees to agree to the following. A, the acceptance of the initial gift or conveyance of the property on behalf of the trust and acknowledged the delivery of all property specified in Schedule A. B, the acceptance and agreement to conduct the trust affairs in good faith in conformity with the terms and conditions set forth in the contract and its inherent trust provisions. C, the agreement to exercise their best judgment and discretion to conserve and improve the property of the trust estate in accordance with the decision of the board of directors or trustees. And D, the agreement to, upon final liquidation of the trust estates, to distribute the assets to the existing certificate holders. Article 7, Resignation and Removal of Trustee or Officers. Section 1. Any trustee, trust manager, or trust officer may resign from their duties with the trust by appropriately providing 30-day written notice. Section 2. The secondary trustee, which is the successor trustee, may be removed from the office for gross negligence of their duty. So A is removal is done by a unanimous vote by the trustees or the board, and B by mandate of court when guilty of fraud. Section 3. In the event of death, resignation, or removal of office of a trustee, the board of directors or trustees shall by unanimous vote either appoint a successor or reduce the number of trustees by 1. Section 4. If there is no trustee left to vote for a successor, the beneficiary may apply to a court of competent jurisdiction to appoint a new first trustee, who shall have the power to appoint their trustees. Section 5. Any new trustee shall abide by the original trust contract and shall not dissolve, terminate, or impact the day-to-day operations of the trust. If there is not a position currently held as a trustee, the beneficiary can become the trustee. Article 8, Annual and Special Meetings. Section 1, the trustee shall provide for the annual meetings, and special meetings may be called upon once or more than once by the trustee upon 3-day notice. Section 2, a majority of the board shall constitute a quorum for conducting businesses at any meeting. Section 3, meetings may be held anywhere in the world, and the trust would pay for any and all expenses connected to the meetings. Section 4, participation and voting at any meeting may be done by telephone, internet, or electronic mail, or physical mail, or text message, any way of communicating. Section 5, any actions taken on behalf of the trust shall require a unanimous vote of those present. Article 9, Limited Liability Trustee. Section 1, the trustees shall, in their capacity as the board, assume and incur any such liability as shall attach to the trust assets. Section 2, the liability shall not jeopardize their personal holdings or accounts, and they shall be reimbursed by the trust for any losses they should suffer for any reason while providing services as a trustee to the trust. Section 3, no trustee created by this indenture shall ever be held liable for any action or default of any trustee or any other person in connection with the administration and management of the trust unless caused by the individual's own gross negligence or by commission of a willful act of breach of trust, which means that the trustee is not responsible for another trustee's decisions, okay? And they are not going to be held liable just in case there is any type of, court issue or litigation. The trustees' personal house, car, assets, bank accounts will not be seized due to the issues that are inquiring or happening within the trust. Article 10, Beneficiaries. Section 1. The beneficiaries of the trust shall be holders of the UBI, which are units of beneficial interest. There shall always be 100 trust beneficial units in issuance, no more or no less. These UBIs shall be transferred by the Board of Trustees or Directors in accordance with the grantor's wishes. The grantor or the first trustee may add any additional beneficiaries or remove any deceased beneficiaries. Section 2. No TCU or trust certificate unit holders shall transfer any rights of their TCUs until or unless such transfer is first approved by the Board of Directors or Trustees. Section 3. The number of TCUs held by the beneficiary as a percentage of the total number of TCUs